today's video, we discuss the basics of federal and state anti-kickback and fee-splitting prohibitions. Hi, I'm Michael H. Cohen, founding attorney of Cohen Healthcare Law Group. We help healthcare industry clients just like you navigate healthcare and FDA legal issues so you can launch or continue to scale your health and wellness product or service. Let's start with some definitions. What is a kickback? Simply put, a kickback is an unlawful inducement to refer a patient for healthcare services. That's what it is. Under federal law, the Federal Anti-Kickback Statute, also known as AKS, can apply to all practitioners, not just physicians, where federal reimbursement monies are involved. The concern is that the practitioners might benefit from cross-referrals and be induced by the financial benefit to cross-refer to Medicare reimbursed practitioners, irrespective of the medical benefit to the patient. Now, states have their own mirror laws prohibiting kickbacks and fee splitting, and note that while the Stark Law is subject to exceptions, with kickback prohibitions, you have what's known as safe harbors. If an arrangement falls within a safe harbor, it is likely that authorities will not pursue enforcement. However, so much depends on the specific facts and circumstances, which is why it's important to have legal counsel review a proposed arrangement to evaluate the risk that the arrangement itself might be deemed an unlawful referral as opposed to falling within a legitimate safe harbor. When healthcare businesses and medical group utilize management and marketing services of others, as in the so-called MSO model, the safe harbor they typically rely on is the one for personal services and management contracts. Now, this safe harbor requires that a whole bunch of criteria be met. Let's go through them. Number one, the agreement's in writing signed by the parties. Okay, easy peasy. Number two, the agreement covers and specifies all the services to be provided. Number three, the agreement specifies that any services to be provided on a part-time basis and the schedule and length and charge for such services. 4, the agreement is for at least a year. Sometimes that can be thorny, depending on termination provisions. Number 5, the aggregate compensation to be paid over the term of the agreement is set in advance. That one can be tricky. It's got to be consistent with fair market value in an arm's length transaction, and it cannot be determined in a manner that takes into account the volume or value of any referrals or business otherwise generated between the parties. 6, the services performed under the agreement do not involve counseling or promotion of a business arrangement or other activity that violates any state or federal law. And 7, the aggregate services contracted for do not exceed those that are reasonably necessary to accomplish the commercially reasonable business purpose of the services. Now, another huge safe harbor you'll find, another huge exception in Stark, you're going to find this carve out for a bona fide employee. Compensation must be reasonable, fair market value based on arm's length negotiations, and not based on the value or number of referrals. An employee is not an independent contractor. Somebody outside finds that very amusing. If the payment is hourly, it could be seen as one that varies based on the value or number of patients, and thus fall outside what's allowable. Because most arrangements aren't cookie cutter, there are no cookie cutter deals, it takes experienced legal counsel to assess whether your business model is likely or not to trigger serious anti-kickback and fee splitting enforcement concerns. If you're interested in an early read on your healthcare business model, oftentimes you can benefit from a legal strategy session where we can do that with a member of our experienced legal team. Thanks for watching. If you still have questions, you know what to do. Click on the link below to send us a message or book an appointment, cohenhealthcarelaw.com/contact. Thanks for watching. Here's to the success of your healthcare venture. We look forward to speaking with you soon.